Randy Barnett, welcome to Dad Saves America.
Great to see you again, John.
So yes, before we started, I was saying how we had met a long time ago. I was a doe-eyed young libertarian, and I went to this cool event, and you were talking. It was in the aftermath of the passage of Obamacare, the Affordable Care Act, and you had a lot to say about it. You've got a great new book that I have not read.
Full disclosure.
Full disclosure to the viewer, because it is massive, and I read like a child, so it takes me forever. A Life for Liberty.
And your review copy didn't have the color pictures in it. Your review copy only has the black and white pictures.
That could have enticed me.
That's right.
The color pictures, because I'm a child. So you are a constitutional law expert. We had your student Ilya Shapiro on the show. He talked about being invited to Georgetown. You teach law at Georgetown.
Now, Ilya was not my student, but I did invite him to work for me as the executive director of the Georgetown Center for the Constitution, which is what I founded at Georgetown. But we had a bumpy road. We hit some speed bumps along the way, and ultimately he ended up at the Manhattan Institute instead.
Yes, we talked about it, and that was an unfortunate set of speed bumps, to say the least.
It was a pretty draining and depressing 4 months, because that's how long it took to unfold.
Yeah, actually, let's start there, because we had Ilya on the show. So you invite him to be part of this center, to run this center.
Right.
Like, what was why him?
Because I was having dinner with him in D.C. at a wonderful French restaurant, and he sat down, and the first thing he said is, "Randy, can you hire me?" So that's why him.
Really?
Yeah.
Because he asked?
Well, that was the beginning. And my first answer was no, I don't see how I can. But by the end of dinner, it seemed like might be a good idea. Now, it might have had something to do with alcoholic beverages that were being consumed. But for whatever reason, by the end of the dinner, we were sort of thinking that might work out.
All right, real quick. If you like what you're seeing and you want to see more, be sure to hit the like button, subscribe to the channel, and ring the bell. It lets YouTube know that you want to see more Dad Saves America, and it helps spread the word. So it's one of the best things you can do to support what we're doing. And now, back to the show.
You know, my mother has told me from an early age, if you want things, you need to ask for them. And I think there's an important dad lesson. Kids, if you want Randy Barnett to hire you, you've got to get him drunk and ask him, and it can happen.
It happened, but then to both of our chagrin, the stuff hit the fan.
Yeah. So speaking of stuff hitting the fan, we've got a very interesting moment, right? So we have the most conservative Supreme Court. Is it ever?
Well, certainly since before the New Deal.
And of course, the usual suspects on the left, who only seem to know how to say this is an attack on democracy, consider the Supreme Court as it currently is constituted to be some new grave threat that is somehow different than when they had a majority and were ruling in favor of their philosophy. Help me as the layperson that isn't, I'm going to take off any kind of ideological hat. I hear this rhetoric about the Supreme Court, and that it's like somehow worse or off the rails, or what's going on there? Is there any truth to that? Is it just partisan rhetoric? How should I think about that?
Well, first of all, I've already agreed with you that it is a conservative court. We have a conservative majority of 6-3. And that is new, and that's going to have implications. But how did that come about? Well, when we didn't have a conservative court, when we had a very liberal court, and the left was quite happy with that. They thought that was terrific. I mean, if you were a minority, which I was, dating back to when I was 12 years old and I debated on behalf of Barry Goldwater in front of my entire grade school and junior high school student body.
So you're aiming to be the popular kid.
In a largely Democratic working class town called Calumet City, Illinois. I was, I certainly understood that the Supreme Court was not, my friend. It was not doing the sort of thing. And it continued through when I was a law student and reading all the Warren Court and the Burger Court decisions. And then what's the response to that? If you object to it, is, well, win some elections.
Elections have consequences.
This came. They said that liberal court came about because of FDR and the New Deal, and then the succession of victories, electoral victories, and the fact that the Republican Party started to emulate the Democrats when it came to these sorts of things. And so if you want to change the court, then you got to win some elections. You got to have a political movement. Well, guess what? People who were right of center, they started a political movement. The Federalist Society is part of that. It's not a vast conspiracy. We can talk about what it is and what it isn't, but it's clearly part of the conservative legal movement. And, you know, some conservative Republicans started winning elections, like famously Ronald Reagan, who was condemned as an extremist and a radical, and because every Republican. Yeah. I just realized, I just discovered, I just learned on Twitter, on X, when we were talking about, I said when, you know, they called Barry Goldwater a Hitler figure when I was a kid, and that's the earliest memory I have. But they said this all goes back to Truman accusing Dewey of being a Nazi or a Hitler person. So it's like a standard playbook. But
wasn't that a little bit like too soon?
Yeah.
For Truman?
Actually, apparently there was even another one from 1933 where Roosevelt was accusing the Republicans of being fascist. So as soon as Hitler existed, they started comparing Republicans to Hitler. Apparently, this is part of the playbook. But the point is that we have a political system in which politically elected presidents choose or to nominate people to be on the court, and they must be confirmed by a politically elected Senate. That means, you know, what I was being told that when I objected to the Warren Court is that, you know, win some elections, they're right. Well, that's what happened. Some elections were won. And through that and some happenstance, Ilya mentioned that even in your, because he has a great book on this, by the way, on judicial nominations. He knows more about this than I do even. But through happenstance and luck and winning some elections, we have a conservative court of 6-3. It also crucially involved Mitch McConnell deciding that the Scalia seat was going to be remaining open until we see the results of the 2016 election. That, by the way, was pretty ballsy, and something. It was, and that was something
uncharacteristically so.
Well, the thing about Mitch McConnell, everybody thinks he's a squish, but in fact, he's only a squish about the things you care about. About the things he cares about, he's not that much of a squish, and he cares about judges, and so that's what he did. And whoever won the election was going to fill that seat. He didn't. If it was Hillary, she was going to fill that seat. And I'll tell you, this is something I do discuss in the book. I thought Trump was going to lose. And I thought that seat was going to be filled by Hillary. And I thought that once that happened, it was going to be game over for the 25 years that I put into the conservative legal movement, developing the theory of originalism, arguing for it. If that seat had gone the other way, the court would have gone the other way. And there would have really been no point in my sticking with this program. And my intent, because I thought Trump was going to lose, was to retire at that point. Or first,
I'm done, I'm out.
Before I retire, I was going to go back to teaching contract law, which is what I taught before I taught constitutional law. And then when I was ready to retire, I would just retire sooner rather than later. I would have been retired by now for sure. It would have been game over for the Constitution. But I woke up I actually went to, that's the first election that I didn't stay up to see the result of. Because I was going to sleep, it looked like Trump was doing okay. And I thought, that's not going to work. I have to teach a 9 o'clock class in the morning. I get up really early. And they're going to, at 3 in the morning, they're going to pull the thing and and he'll have lost. So I'm going to bed. And I woke up the next morning and he won. And all of a sudden, this whole intellectual agenda that I've been working on, this originalism, to try to restore the original meaning of the Constitution, restore the lost Constitution, which was the title of my first book on the Constitution. We were playing with the house's money. We were in Vegas. We could call it playing with the house's money. You win big in the beginning, you play with the house's money, or we were on bonus round, if we're talking about a game. But whatever it is, the book tells the story about how we went from that moment to the moment where we finally have 5 justices who identify as originalists, for whatever that gets you, which we could talk about. An additional Chief Justice Roberts, who's a conservative for sure. He's not an originalist. That's 6. And it makes a big difference. And the political process is responsible for this because that was the original design. The design is these positions are going to be filled by people who are in the political process. That's what happened.
So,
but the people on the other side, the progressives, they love democracy when they win. And when they don't win, they're not they all of a sudden believe in other things, or their version of democracy doesn't include winning elections.
I find the cries about democracy from a movement that has any relation to the progressive era bizarre, because this sort of the rhetoric around democracy is the progressive movement was very deeply anti-democratic along a lot of major dimensions. I mean, Woodrow Wilson basically created created the Fed, or it was under his watch that the Fed, which is the least democratic institution in our American structure, maybe aside from the Consumer Finance Board that Elizabeth Warren created, like that might be even less democratic than the Fed. So it doesn't seem, it seems like the entire administrative state apparatus seems deeply, deeply anti-democratic. And this is a good place to start on some current stuff before we go.
Can I say a few words about democracy before we move?
Please.
You set this up. 2 books ago, the book before last that I wrote is called Our Republican Constitution, Securing the Liberty and Sovereignty of We the People. It's also a trade book, which makes it much more accessible to the general public. It's one of the books, along with my memoir, that my wife has read and likes. The other books, more scholarly, maybe less so. But anyway, in that book, I try to explain the degree to which we are a republic and not a democracy and what that means. And in fact, the term democracy can mean many things. But what you mean by democracy is the majority should rule, which is what sometimes they mean when they've got the majority or they think they do, then we are not a majoritarian democracy. We are a Republican government that's structured to put constraints on the majority. Now, the majority does get a voice, a very important voice, and we need that voice, and we need it today more than ever, which is the voice of checking what the government does and even checking what private parties do. So the majority gets a voice, but their voice is structured and constrained by limits, and those limits have to be enforced by judges. And so if you are a Democrat, if you're that kind of democracy person, then judges are suspect because they're thwarting the will of the people when the democracy is the will of the people. The legislature is supposed to be the will of the people, even though they're just a bunch of people. So that's if you're a Democrat. But if you're a Republican, I mean small r Republican, I'm not talking about the party, then you believe in judges having to do their duty, and the duty is to hold the other constitutional actors to their powers, to the limits on their powers. And that's sort of the difference between a republic and a democracy. And Democrats like democracy. There's 2 things. They're either defining democracy to mean whatever, including judges, because they sometimes like judges when they control the judiciary, or they just mean majority rule when they win, and they're not likely to like it that much when they lose. But conservatives have done, many of the same things. They have committed many of the same faults in liking democracy when they're in the majority and liking constraints on democracy when they're not.
It does seem like the First Amendment paves the way for this mentality, right? Which is, I love freedom of speech so long as you're not saying anything that I think is gross. And when you're saying something I don't like, then suddenly my freedom of speech gets a little more provisional, let's say. So one of the big cases that has been decided recently by the Supreme Court involves this Chevron deference concept. So for those that aren't steeped in this, what is, or perhaps was, Chevron deference?
Right.
And why does that matter? Why should I care about that?
Even though I'm not an administrative law guy, I'm a constitutional law guy, but I did talk about Chevron deference in our Republican Constitution, calling for its repeal. That was in 2016. So we got there 8 years later, which is not too bad. It's a big deal, but it's not a super big deal. Okay. It's a big deal because under the Chevron doctrine, when a statute is ambiguous or subject to multiple interpretations, the doctrine said that the judiciary is supposed to defer to the agency's interpretation of that statute. So let's say the statute could mean A, B, and C, and the agency says it's C. Rather than do their independent due diligence to figure out whether it's A, B, whether the agency's right and it's C and not A and B, the judges should just defer to the agency. Now, this is a problem because the agencies might be expert in whatever the subject matter is they regulate, but that doesn't make them experts in interpreting statutes. That's actually something judges are expert at. So it's not clear why they would be able to why we should defer to their opinion about what a statute means. But here's the other problem. Under the Chevron, and this is something that most people don't realize, under the Chevron doctrine, if the statute could mean A, B, and C, and a Democratic administration, or under a Democratic administration, the agency says it means C. And the courts defer to it because, well, we have to defer. Then the next administration comes in, they say, well, no, it shouldn't be C. We think it should be A. And they switch it. And then the agency says, and then the courts have to say under Chevron, oh, yeah, well, we defer to that too, because it's reasonable. I mean, A, B, and C, whatever that we defer to whatever they decide. And then the next administration comes in and says, no, we want to make it C again, or maybe we want to make it a version of B. And the court says, okay, we defer to that too. In other words, the meaning of statutes can go back and forth with a change in administration, as opposed to the system that exists in every other area, which is the courts get to interpret what a statute means if it's under scrutiny, and the court says it means C. And guess what? From now on, unless the court decides it was really an error, it's going to mean C regardless of which administration it's in. So eliminating Chevron creates not only it not only allows the courts to do what they're there for and exercise their expertise in interpreting statutes, but it also eliminates this sort of back and forth game where the agencies can just do whatever they want.
It strikes me that we have this bizarre situation where the Congress of the United States will pass these massive bills. It's funny to look at the page counts of today's legislation relative to like the Interstate Commerce Act of 1887. That's like, whatever, 15 pages instead of 1,500. But even when it's got 1,500 pages, there's all kinds of stuff that's basically like wishing for things to happen.
Right.
Like the Department of Health and Human Services shall do X, Y, and Z. That amounts to like magic. Like shall make sure prices don't rise for X, Y, or Z. How? So we end up in this world where we have this elected body, our Congress and our representatives, and then the president who signs a bill that passes the bill with a bunch of stuff that leaves a lot of interpretation. And then my understanding of what happens next is that the executive branch then starts to put it into action and generates these things we call regulations, but they're basically just extensions of the law. They're rules that have consequences, that can have penalties, that can impose costs. And then this other thing happens where they will also adjudicate the laws that they created themselves. And I've read somewhere that a bunch of these agencies buy a lot of bullets. So what is going on here with this?
Well,
how are we in a place where it seems like we've got like Judge Dredd rules inside the executive branch? Is that going too far?
No, I mean, we have a deep state in the sense that they have their own thing, and they tend to not be that constrained by other parties. But this is something that's been done by people in Congress by design. They would rather pass feel-good legislation and let somebody else do the work than actually have to do the legislating themselves. One thing I just wanted to add, because I said that Chevron's a big deal, but it's not as big a deal as some people think. The rejection of Chevron, I say, is a big deal, but not as big a deal. Why? Because all that this case has done, Loper did, is to say, if there's an ambiguity in the statute, the courts will interpret it. And so the court's expertise is interpreting statutes. It doesn't say anything about deferring to agency expertise on particular subjects. So if there is, for example, the Clean Water Act will just say the agencies develop an expertise on how much parts per million of X, Y, Z should be in a water supply and what the kinds of piping you should have to have it, that kind of deference still exists. So one of the things that was said when people were howling in outrage about this reversal of Chevron is now the courts will no longer defer to the expertise of agency, and that's not true. Those deference policies still in existence. And they will defer to agency expertise about the subject matter they regulate. What they're not going to defer to is agency interpretations of the statute and whether they even have the power to regulate it in the first place. So consider the Clean Air Act and whether giving the legislature the power to regulate, emissions, harmful emissions. Well, does that include greenhouse gas emissions? Is that a pollutant or not? And that's itself a problem. And it's whether, carbon is even a pollutant. But
Yeah,
I mean, trees.
I thought it was plant food. I thought we breathe out.
Exactly. All right. So there's that. But then supposing they say, well, we can exercise under this statute the power to ban the internal combustion engine. We're just going to phase it out. No more internal combustion engines. Is that the kind of thing that they were empowered to do? Well, when it comes to interpreting the scope of the statute to say, is banning the internal combustion engine for all cars in the United States, is that something within the power of the agency to do? That's something a court can step in and say, no, you've gone beyond. You've gone beyond with the limits of what Congress delegated. If something that major, it's called the major questions doctrine. If something that major is going to be legislated, Congress has to do it, not you.
The one other piece of the puzzle here that I want to understand is this Chevron doctrine or Chevron deference. This emerged out of a court case, right, involving the company Chevron.
Right.
But is that just precedent? So help me understand how that works. Okay, so there's this particular case, and then from that point forward, it's like officially the way the courts must act.
Mm-hmm.
How does that? Because isn't that what passing laws are for? Like, how did the courts? Why is it the courts feel compelled to continue to act on what prior courts did?
Okay, there's very fundamental doctrine that comes out of the common law called stare decisis, which is let the decision stand. And this was very instrumental. This is very crucial to how a common law system worked, because a common law system is a series of adjudications that are happening between individuals that are adjudicated by judges, disparate judges. And when a judge decides to rule, and he's supposed to rule on the basis of what the law is, not what he wants it to be, he has to look around and say, well, what is the law on this subject? And what he looks to is previous decisions. Not just one, but lots of decisions. Well, the law is obviously this, because look what all the courts have done before me. And that's how we maintain consistency, and that's how we develop a rule of law. But that's in a common law system that doesn't have a written constitution. And that's not the same thing as interpreting a statute either. Judges are using the doctrine of stare decisis to develop a rule like, the doctrine of consideration in contract law, or one of hundreds or thousands of other common law rules. Once you have a statute or a constitution to interpret, that's a different question. Now, when it comes
Why is it a different question?
Because the statute is supposed to, and under the common law system, the statute takes precedence. If the legislature says X, a common law judge can't say Y. They have to follow the statute. And so they may interpret the statute narrowly if it's in derogation of common law, but they're not going to say you can't do it. Because under parliamentary supremacy or legislative supremacy, which was the English system, what the legislature says goes. Now, what we did in this country was to modify that system, and we put a written constitution on top of everybody. And that means when the legislature passes a law, that power has to be consistent with the law that governs the legislature, which is the Constitution. And now somebody's got to decide between the legislature's opinion about whether a law is constitutional and an individual citizen who wants to challenge that law, who's right about whether the legislature was acting within his power. That's what a court steps in and does. And now they have to interpret the Constitution to see whether the legislature was acting within its power. Now, once they've done that, that brings us to your question.
Okay.
Do they have to stick with it? How long? Well, they have a doctrine of stare decisis as well. That's what they say. Now, it turns out there's kind of a dirty little secret about this. There's two kinds of stare decisis. There's vertical and horizontal. Vertical stare decisis, when I tell you what it is, you'll say, well, that kind of makes sense. And that is that when the Supreme Court of the United States says the rule is going to be X, the lower courts have to follow it. So when the Supreme Court of the United States
comes in the whole supreme,
in
word.
Fact, it literally does. That is, it is actually an implication of the Supreme Court clause, which people don't even call the Supreme Court clause, where it's called the Supreme Court. And that's not just the label it was given, it's the status it has. And then
the top dog.
In contrast to that, Congress can create inferior courts, and they're called inferior courts.
It's not just random word choice. It's
right.
Superior is the top, inferior is below the superior.
So that kind of stare decisis makes sense, the lower courts, the inferior courts, should not be bucking what the Supreme Court does. And many inferior courts right now are doing that when it comes to gun rights around this country. The Supreme Court says the Second Amendment protects an individual right.
This is the Heller case?
The Heller case. And then later, two terms ago, was the Bruin case. But the lower courts are resisting. In the Ninth Circuit and some other circuits, they're trying, and lots of state legislatures are passing lots of gun laws in blue states and blue cities that are being upheld by some federal judges and the Supreme. So we're not having great vertical stare decisis on some issues. But now, what about what you asked me about was really horizontal stare decisis? How bound is the Supreme Court to its own opinions, its own decisions of the past?
Right.
And the truth is, it's not. They say they are, but they're really not. And we really don't want them to be. And the reason we don't want them to be, which they'll admit, and that is that under this system, only they can reverse their previous decisions. The other alternative is to go to get a constitutional amendment, and that's really hard to do. And so if the Supreme Court doesn't say we were mistaken, then nobody's going to say they're mistaken. So they have to be able to say they're mistaken. So that means the horizontal stare decisis doctrine is pretty a matter of convenience. It's sort of like, if I really like this precedent, I'm going to invoke it to say we should follow it. But if I really don't like this precedent, I'm going to say we should reverse it. So stare decisis is really invoked really as a matter of convenience. Now, there is one way in which I think it's justified. And if the court was doing these things, I think we'd have no problem with it. And that is that supposing that a decision is made on the basis of original meaning, we think the original meaning of the Second Amendment is to protect an individual right. Other people disagree, but that's what we've decided.
As opposed to, I guess, just the formation of a militia, but no other
right, or whatever
use case.
Whatever theory they come up with. They had a couple of different theories they've come up with as to what it might otherwise be. Now, we've decided that. Now, let's say another case comes up. The question is, do they want to reconsider all of that? If that was a well-worked-out originalist opinion, and Justice Scalia's opinion was actually quite good in that case, in Heller, how confident does a future justice have to be before the future justice says, I think Heller was wrong? I would think they have to be pretty confident because it's already been adjudicated. Now, that's different than if the previous decision was not based on original meaning. If the previous decision was based on living constitutionalist principles or policy or something else, then there's not much to defer to. So this is what academics call an epistemic problem, and that is in the future. Because your question was, what if we know this previous decision was a mistake? What should we do? Well, maybe, right. But how certain do we have to be before we, as individuals, can be that confident that the other decision was a mistake? And maybe we defer unless we're really, really confident they're wrong. So maybe that they get the benefit of the doubt. But that's only if they're trying. And if they're not trying, and the Warren and Burger courts didn't really try very hard, then there's not much to defer to.
What comes to mind here pretty clearly is the Dobbs decision, which overturned Roe versus Wade.
Right.
How do you understand the arguments for that? As I understand it, leaving aside my own belief about abortion, which is that it's horrible murder, the original Roe case was pretty bad constitutional law. Even at the time, it's not hard to find fairly liberal pro-abortion legal scholars who were like, yeah, they're kind of fudging. This isn't great, but I'm happy it happened anyway because this is what I wanted to have happen, even though it's shoddy. Was that interpretation fair?
You know the expression, I was told there would be no math on this. I was told there would be no abortion on this podcast. So I was like, this is, I don't know where this is coming from. It wasn't even happening this term.
What's got a huge impact it's the big issue. It's one of the top issues right now.
President Trump said every constitutional expert thought that Roe was wrongly decided. That even people who liked the outcome of Roe versus Wade thought it wasn't well reasoned, which is what you said. And so,
yeah, that was my understanding.
Yeah, but not well reasoned doesn't mean they thought it was wrong. What it meant was not well reasoned meant they had a better argument for why it was right than the Supreme Court did. So just because the Roe wasn't well reasoned doesn't mean it was wrong. necessarily. And it's not, well, what it doesn't mean is everybody thought it was wrong, because all the
Sure.
people who like Roe, it wasn't just because they like abortion or something. It was because they thought there was a better argument that could be made than the one the Supreme Court made in Roe. You know, what happened to Roe is that the conservative legal movement, which we talked about, which is a political movement and responsible for a lot of judicial appointments over a very long period of time, had criticized Roe over a very long period of time, and were constantly being disappointed by Republican nominees to the court who, once they got on the court, like Justice Kennedy or Justice O'Connor, decided to make peace with Roe and not to do anything about it. Well, eventually, they got a conservative majority who were prepared to do something about it. And what they decided to, and the way they reversed Roe is by asserting what they call substantive due process, a conservative version of substantive due process that said that the only rights, the only unenumerated rights that judges should be able to protect are the ones that are deeply rooted in the nation's tradition and history. That was the conservative theory of substantive due process that had been developed for years in order to be put to this use. And when they finally had the votes, they put it to the use that they devised it for, which is to say, you cannot claim that a right to an abortion was deeply rooted in the nation's tradition and history, and therefore could not be regulated. It could not be stopped by legislatures. And so that's how Roe got reversed. It wasn't on the basis of original meaning, although this outcome could be argued as consistent with original meaning. They didn't use originalist reasoning. They used substantive due process reasoning that they had developed precisely for this purpose, which is to reverse Roe, because it didn't meet the standard. But that standard was precedent. The standard was decided in a case called Washington versus Glucksberg, which is the assisted suicide case out of the state of Washington, in which the court adopted for that case this deeply rooted in the nation's tradition and history standard. And so Dobbs was following precedent, stare decisis, by applying Glucksberg to abortion.
This is, I think, what makes this so challenging, is because as soon as you try to understand these cases, you end up with this chain of reasoning that's multi-layered. And
this is why we lawyers make the big buck. This is why constitutional law professors are never off the clock. We work 24/7. We're on call, just like ER doctors or EMTs. That's us.
Or it might be the reason why the founders weren't super thrilled about the idea of lawyers running the government, right? Couple ways you can look at that. So you brought up the stare decisis, this sort of relying on the prior judgments and adhering to them. The times I've heard that as a layperson has been in these nominating the Senate hearings, and I think it's generally been code for, are you going to uphold Roe, or something like that often, like, oh, I think it even came up with Coney Barrett.
It also comes up with gun rights cases when Democrats are being nominated too. So it's a little trick they play during the confirmation hearing, which is they get asked about a question where there's some reason to believe that that they're going to reverse some big case that the other side cares about, whichever. In the case of abortion, it was the Democrats who cared. In the case of gun rights, it's Republicans who cared, but whatever. And now you're sitting there as the nominee and you have to answer this question. So they developed this answer, and I think it was Justice Kagan who first developed it, or maybe it was Justice Ginsburg who did. I can't remember now. Ilya is the person you should have been asking about this. He wrote a whole book about this. But one of them came up with this dodge, which is to say, Roe versus Wade is the law of the land, or Heller is the law of the land. It is the law of the land. I will follow the law. That is the law. Heller is the law. And that's a true statement. On the other hand, once you know the dirty little secret of stare decisis, which is that they don't have to follow their decisions once they're on the bench, and everybody knows this is true, then their statement that is the law doesn't tell you anything about what the law will be once they start voting on it.
Yeah, interesting. The other big case that just got decided is this issue of presidential immunity. And I was reading into it a little bit before we sat down together. And I want to actually read it deeply because it's being talked about. I want to be educated, although it's hard to. There's always a question of, like, how deep do you have to go before you have an opinion that's even remotely informed? And with some of these issues, you have to go so deep, you're like, cost-benefit analysis kicking in here. But
well, now you know how I feel all the time.
It's like
all the time.
Do you have a take on this? Because Justice Sotomayor's dissent was quite scathing, basically saying, hey, now the president can order SEAL Team 6 to assassinate people and then they'll be immune. And it does. I went back and looked at the Constitution, and actually the powers of the president, there's not that many words devoted to the powers of the president. So that didn't help me either. I'm like, where am I turning to understand what under the office of the presidency means? Because the Constitution doesn't give a lot of room. It doesn't say that much about what the president can and can't do.
Right.
So how should I understand this as someone who's like, I don't care about whether it's good for Trump or not. I just care about, like, is this good for America?
Well, first of all, it's not an originalist opinion. There's virtually no originalism in Chief Justice Roberts' opinion. I told you at the beginning that he's not an originalist, and this is a good example of when he's not being an originalist, and that is this was what's called a functionalist opinion. It's not based on the text of the Constitution. It's based on the separate functions, and that according to functionalism, something is impermissible if it unduly burdens the function of another branch. So this is a judge-made doctrine. I'm not saying it's a bad doctrine, but it's a judge-made doctrine that's been around for a long time, and he applies it. I mean, he basically talks, as you read the opinion, he talks about the steel seizure case, Harry Truman, and whether he could seize the steel mills because of the needs of the Korean War. This is where this test was used. So it's based on precedent. It's based on functional analysis. It's not based on original meaning. It would have been really nice if either he had done that or one of the other justices had actually filed a concurring opinion to tell us how this squares with original meaning. So that's a problem with the majority opinion. On the other hand, it's really trying to be a moderate opinion. It's trying really hard to be a moderate opinion. I listened to the 2.5 hours of oral argument again the weekend before the opinion was announced. And in that, the federal government conceded that there were core powers that the president had that Congress could not regulate and could not interfere with. That's the government that conceded that. President Trump's lawyer conceded that some of the acts that he's been charged with are private acts, and therefore he's not immune. So you had this concession going on in oral argument, and then the real debate is the stuff in between the core powers and the private acts. If they're not strictly private, first of all, it's not clear. The lower court did not distinguish between the private acts and the official ones because they said there was no immunity. And the circuit court, the D.C. circuits, didn't distinguish between the private acts and the official ones because they said there was no immunity. So if there's zero immunity, they didn't have to do any of the work. What the Supreme Court said is, okay, there is a difference between a core function, an official conduct that's not a core function, and a purely private act. You go back now and try to sort out this complaint and see what's in and see what's out. That's what the court did. This is unprecedented. Now, the people who don't like President Trump say, well, it's unprecedented to have a guy who's as lawless as this guy. Okay, maybe you can believe that if you want to. What is unprecedented is to have the Department of Justice and the White House on their own initiative and in collaboration with local prosecutors in Georgia and New York engage in what is called lawfare to try to criminalize their political opponent after they leave office. This is something that we've never seen in this country before, and it's extremely dangerous. And I believe, and Chief Justice Roberts mentions this in his opinion, and the dissenters don't mention this in their opinion, and that is if the Supreme Court did not do. Now, whether they made it a right decision under originalism is one thing, but if the Supreme Court did not do what they did in this case, we were on our way to banana republic territory, where outgoing presidents are always prosecuted by incoming presidents. Outgoing administrations are always prosecuted by incoming administrations. This happens all around the world. It has not happened here. And that's something that the Biden administration is responsible for. That is what started this. And the evidence that that's what they were doing is the sort of the bogus nature of so many of the legal theories that they've been using to prosecute the president. Not all of them are as bad as some of them are, but the fact that there are so many of them shows this is a concerted campaign to criminalize your political opposition, either to punish them as they're on the way out the door because you don't like them and they deserve to be punished, and there's Democrats who feel that way about Trump, or to prevent him from being elected again, which they also want to stop from happening. This is not what the law is for. And what this opinion did have the effect of doing is cutting, hopefully, and I believe it was meant to do this, cut short this downward spiral of political prosecutions. And once it gets started, you can't stop it.
It's a Hatfields and the McCoys.
Once you get, it's exactly right. Hopefully, like fingers crossed, this opinion cut that short and saved us.
What if I want these people to be put in jail? And I mean that partly as a radical provocation, but partly because it sure seems like, as someone that's concerned about the constraints on power, that the presidency has become totally out of whack. For example, it appears like you can be president and assassinate Americans on foreign soil as part of wars that were not declared by the U.S. Congress, which seems like that's like a real violation of like the actual written laws of the Constitution, because we don't like, and it also just seems like full-blown thuggery masquerading as being president. And there's a lot of examples like that, especially in the foreign policy, where I tend to be more dovish, or at least be like, let's not blow up the world. Isn't this maybe good? You know, shouldn't we be impeaching these people a lot more often? Why not throw them in jail? They're bad guys.
Criminalizing your political opposition is a bad idea. When you have political disagreements, the real source of the problem is that Congress has passed so many laws that empower the president to do so many things and to use so much discretion in the course of doing so many things that the president is acting lawfully when they do all kinds of things that maybe ultimately, that if a private citizen did it, you could call it a crime. But the real solution to that is to cut down the powers of the president and at least subject it more to the rules of law when it is not something that's one of his core functions that Congress is not supposed to interfere with.
I mean, that comes back to the Chevron issue, right? It was what I hear is like, oh, so what we have is we have a Congress that passes a bunch of unicorn laws about make the world perfect, Mr. President, create some agencies, do whatever you got to do, tell people they have to buy products, for example, with health insurance or whatever. And then the president now has all these weapons laid out on his table to use against us.
And Joe Biden has been doing that. I mean, he wants to forgive a bunch of student loans.
Right. And the court, I mean, didn't the Supreme Court say, no, you can't do that?
Yeah, but he finds another law. They keep finding laws that under like it's a veterans law or something. They keep trying to find laws that you can use. Now, it's pretty outlandish, so I think he could have been prosecuted for that if he didn't have immunity. So again, I think the second biggest beneficiary of this rule was President Biden. That's my hot take.
I'm going to come to originalism, which I know you want to because it's important in it.
I just want to go where you want to go, John. This is your show. So you get to call the shots here.
The thing that I want to do is I want to better understand this notion of common law. So you referenced it.
You have nothing but easy questions for me. These are.
I'm being selfish here because there's a lot of this I don't understand. I don't think I have all that great a grasp on. I have some notion of it, but so my notion of what common law is that it's an inheritance of our British tradition, and that it's essentially a kind of emergent law. It's the law of two people come before a judge. They have a case that is unclear what the right answer is. In terms of just pure logic or looking at the laws that have been passed. And so the judge has to look around at what seems to be reasonable, or what seems to be what people are expecting or something like that. Help me understand, like, what is the basic unit of common law? Like, what is this thing?
Well, the post-19th century, the 20th century version of common law is kind of like what you described. It's called judge-made law, where judges do what's reasonable. But that was not the historic theory of common law prior to Oliver Wendell Holmes writing his book on the common law, let's say. The historic version is something I mentioned to you earlier, and that is that a judge is supposed to decide between two claimants who has the strongest claim of right. And they're supposed to decide it on the basis of pre-existing law, not what the judge thinks is reasonable, but pre-existing law. Now, you got two claimants. You don't get into court unless you can claim a right. You don't come into court because you deserve it. You don't come into court because you want it, you desire it. You come into court because you have a right to it. Now, the other guy comes into court and says, you don't have a right to it because I have a right to it. Now we have two conflicting claims of right. And the only thing the court is supposed to decide is who has the stronger claim. They don't have to decide in some absolute sense who's the best person. They don't have to decide in the absolute sense what's the best policy. They have to say between this guy's claim of right and this person's claim of right, who's got the stronger claim. And the way they resolve that, if they can, is by looking at the way other cases have been resolved. And they say, look, when we come around, around here, if we add up all the reasons that these cases have been decided in the past, then this person has the stronger claim of right than that person. That's how the common law is supposed to work. It's supposed to be applying the common law, the law that is already shared in common across disputes. Now, this may have been, in some respects, a myth. I mean, to some degree, I should say. But that was the aspiration of the original common law. Now, where are we going with this? Why does this intrigue?
Well, I want to understand the building blocks to where we are as American law now, because there's
well, this was
we don't learn this stuff as kids,
but this is
we get out of college and we don't know it. It's like let me be a proxy for our civics ignorance.
This is how most private law disputes, I mean disputes between private parties, and you and I get into an argument about who has the rights to the show or whatever, and then we have to take it to a third party. That's a private law dispute. This is how private law disputes were basically resolved. Legislation was rare.
Yeah, so maybe as an example, so I've been a producer for a long time. One of the things you do as a producer is you deal with a lot of contracts, and those contracts inevitably cannot contain every conceivable angle for every outcome imaginable. You have to do your best to come to an agreement with whether it's someone you're hiring or someone you're going to partner with or someone whose likeness you're going to exploit, like I will with you, and say, okay, here's what we agreed to. Here's some language that we both agree makes this worth signing our names at the bottom.
Right.
And we both know there's a bunch of like black holes in here that some of which you could drive a truck through because otherwise it'll be 400 pages and the deal will never happen. And we want to work together.
Yeah. Not only will the deal never happen, but and I used to teach I was mainly a contracts professor before I was a constitutional law professor. The book talks about why I got into contracts and how I eventually segued out of it. But in fact, when I teach contract law, what I say, what I say to my students, and when I teach con law, actually the first day of con law, I say the same thing about the Constitution. And that is you can't put everything in. And if you ever were negotiating with somebody who wanted to put everything in, you would soon conclude that person is a crazy person.
Or maybe crooked.
Maybe, but mostly they would be insane. I mean, it's like, what about this happens? What about this happens? It's a full eclipse of the sun. And what about this? And it's like, okay, I don't want to do business with you anymore because you're not there. You're not all there. We have to go forward on the basis of incomplete agreements in that sense and hoping that it's going to basically capture most of what we have, what's likely to happen. So that's really, and of course it is true, as you know, that's how these contracts get longer and longer because lawyers because something happened. Some stuff happened, right? And then after the stuff happened, somebody puts a clause in about that stuff. And from then on in, that clause is in every contract because that happened one time.
It's the boilerplate.
It's the boilerplate because something happened. And the stuff happened and you need to do something about stuff when it happens.
It's below the surface. What has generally served me well, and I think most people will say this, is below the surface is the paper is only as good as the trust, the actual trust that's below the surface of the paper, the contract. And it's never going to be perfect trust because we both maybe any one contract, just in commercial agreements, there is a zero-sum game. Like if we're trying to figure out who's going to own what percentage, there's a zero-sum game. If I get more, you get less.
Right.
And it's just a question of where does that dial resolve itself that we want to move forward instead of part ways. So how does that then what's the bridge from two people having a contract? How does that start to work its way up into the system of law? Like the bigger picture? Is there a bridge there that I can understand?
You've lost me, John.
Well, let me put it this way. So here you said that there wasn't a lot of legislation in the old days. What does that mean? What there weren't?
Yeah,
there wasn't a parliament.
There was, but they passed occasional statutes here and there about special things. They did a lot of private lawmaking as well. They gave rights to different people and stuff. You spent money, did things like that. And so most of private transactions were governed by judges. Actually, before there were judges, there was the law merchant. There were merchant courts that decided these things. And then the common law judges took over the business by saying, we're going to import the law merchant. We're going to do all this. We're going to get the business, because they charge fees, by the way. The judges charge legal fees for having adjudicated the case. We want this business. And so we're going to honor the law merchant as we take over this business. And that was another reason why it was a pre-existing law, the pre-existing law merchant, that they were supposedly enforcing in the common law courts. But then gradually, in the late 19th century, the progressive movement started, and the progressive movement was a big fan of progressive legislation. And we just started to have more and more legislation until we now have, 3 felonies a day, in the words of Harvey Silvergate, which I think Ilya quoted to you in the podcast, right? And so there's just so many statutes out there, you don't even know when you're guilty of stuff, because there's just too many statutes to be sure about. And that's true of government officials as well. So what do you do in an age of statutes? And then if you superimpose upon that administrative law, which are all these regulations that are not statutes, then judges are just operating around the margins at this point, when the common law system is not working at that point anymore. Now we have a system of legislation where judges are just trying as best they can to interpret the statutes or interpret the regulation as best they can.
I think there's a couple questions below the surface which are leading me to ask these things that can sound a little like childishly fundamental. One of which is, we are both libertarian-minded people, fairly radically so. And so what would it look like to have a radically freer society in which we still turn towards judges and towards a legal system? That's one thing below the surface I want to talk about more. The other is, we have this collapsing level of trust in our institutions in this country, and I think in the West more broadly. And part of that, at least, there's a lot of reasons, I think. One of them, though, is everything's so darn complicated. There's so much complexity. Even in this conversation, there's an enormous amount of complexity about how the system works. And so I feel like we have a rising energy on both the left and the right to say, down with the system. The system is broken, rotten, corrupt. And I think in America in particular, we love to sue each other all the time. Like we're sort of like a joke on that, at least compared to, say, Europeans. Like, we are a sue-happy country, it seems like. So I feel like we're tied in knots around the law. And I'm hoping you can help me understand where some of those ties are good and they bind us effectively, and where they don't.
As I said before, it's been a long day. I started at 3 a.m. your time to come from the East Coast to the West Coast. And what time is it now? It's my time. It's like 8 o'clock.
Come on, Randy. You need some coffee?
It's you're asking a lot. Here, I'm going to say something. It's going to sound weird, weirdly non-responsive. One piece of legal advice I have to people is the one I follow myself, and that is always put a private arbitration clause in your contracts. Do you put private arbitration clauses in your contracts?
That's right. I did.
And do you know which firm you use? Was the American Arbitration Association?
I think it is.
Yeah, so do I. So I just negotiated a contract with my publisher, my casebook publisher, about licensing some videos that I made, and I got their contract, and it was a reasonable contract. We negotiated some terms, but at one point they said this contract shall be governed by the law of the state of whatever state they picked, and I just crossed that out, and I said this contract should be subject to binding private arbitration. And they agreed to it. And I do that in all the contracts that I enter into if I can. And most commercial contracts already are that way. I learned this lesson because I got into a dispute with T-Mobile. This is a long time ago, and it was about roaming charges for data I'd incurred when I went to Europe, and they wanted to charge me like $1,700 back.
Oh yeah, you can really get screwed on the overseas travel.
And so they had a binding, so they wanted me to pay the $1,700, and I wanted to dispute this. I wanted to reach some compromise. Come on, we can be reasonable. Let's make it $850. Let's split the difference, something. And they wouldn't. The customer service, nothing we can do.
Shocking.
All right. So I said, well, I got nothing to lose. I have never really gone to arbitration before. I've always recommended people go to arbitration. So I'm going to try it. So I just filed an arbitration. They have a private binding arbitration clause in their contract with us. Check your cell phone company agreement, your terms of service are going to be governed by private arbitration. So I said, okay, I can do this. So I looked it up, how you do it. And, and I filled out my 1-page complaint and I filed it with the American Arbitration Association along with a check to cover the cost of the arbitration if I lost, because that's what would happen if I lost. And I waited. It's a big T-Mobile, right? And, I don't know what $1,700 means to them, but it was a lot of money to me. This was like 15 years ago. And so I said, I waited. And they had set a date. The AAA had set a date for the hearing. And the hearing was coming, and it was coming up soon, and never heard back from them. The day before the hearing, I get a call from the president's office of T-Mobile. Not the president, but the president's office.
Yeah.
And it's a woman on the phone. And she said, the other thing is I did not only sue for the $1,700. I also sued for treble damages on the grounds that they had engaged in deceptive practices about they were going to charge me. So it actually was a lot more than that.
You're fighting for all of us on this one,
right? So at any rate, it was a lot of. I made it into a lot of money, and so she said, well, we're not going to pay treble damages, and we're not going to pay 3 times $1,700. And they said, what would you take? And I said, well, I would take double. And they got okay. So they wrote me a check for double. Oh, actually, I take it back. As soon as I filed the arbitration claim, they credited me the $1,700.
Oh,
that was like immediate. And now I'm waiting but the arbitration hadn't gone. We hadn't gone to arbitration yet, so there was still the treble damages that was still out there. But I've already pocketed. We're like in Vegas now, so I already pocketed the house's money. I got my $1,700 back.
So now the pound of flesh.
And so now it's all it's all profit at this point. So then she said, we're not going to pay 2 times $1,700. And I said, well, how about 1 time $1,700? Just give me $1,700 more. And they said, okay. And they sent me a check for $1,700. Now, this is a miracle. I mean, this is like magic. No, it's not a miracle. It's like magic. And basically, I was not going to go to federal court to sue T-Mobile over $1,700. I would have had to pay it. But I got the money back. And this is something everybody can do. So this is an example of how even today, especially because the Supreme Court likes private arbitration. The left doesn't like private arbitration, but I love private arbitration because look what it empowers the individual to take on big companies because you can do everything informally. You don't need a lawyer. They have to hire a lawyer. They have to send a lawyer in because they're a company. They only can exist through a lawyer.
Right. So they do the math and they're like, this is going to cost us.
They have to pay the
$10,000
legal fees of whatever firm it is but I don't have to pay anything. I could just go myself and you could go yourself. But anyway, so the president's office called me the day before the hearing and we settled on the $1,700 more. And that was the end of the lawsuit. So I would say that's a good part of our legal system. But you have to put it in your contract or read your contract and see that it's there.
We're going to clip this section under the how to get out of being screwed by the cell phone companies. Even though I'm not anti-business, I'm a free market guy, but there's a lot of screw jobs going on when it comes to your cell phone contracts. Okay, so here we are. We're at the birth of the nation. We have this common law tradition of how to adjudicate disputes, mostly privately, and we're trying to we're constructing this Constitution as framers, founders. And we write a bunch of rules down. We try to do our best to do this thing. How do you understand what the intentions were? And obviously they played out in the Federalist Papers, right? And other things. But how do you understand what the goals of the Constitution of this country were at the time?
Right. First of all, I don't think a constitution is a contract. It's a writing and has that in common with contracts. So as a contracts professor and somebody who believes in freedom of contract, I don't think the Constitution has the consent that contracts have. Contracts have 2 people, both consent. If you even go online and you click, I agree, you've consented. You may not know what you've consented to, but you've definitely consented to something. The Constitution doesn't get the benefit of that. However, it is a writing, and it was put in place for a particular reason, and it was put in place as an innovation to subject those who govern us to law. The Constitution is not the law that governs us. The Constitution is the law that governs those who govern us. And how are you going to subject those who govern us to law? How are you going to do it? Well, what they decided—
Who watches the watcher?
Right. Well, who watches it, but also what is the law that governs them? Well, you have to put it in writing. Because otherwise, how are you going to know what it is? So they put it in writing. It gets ratified by the states, however the ratification took place. I don't think that's the same thing as you and me consenting to it, but that's how it got to be made a matter of positive law. And the people that are subject to the law that governs them can no more change it to something they prefer than we can change the law that they make to govern us to something we prefer. So if we're driving down the street and the government set an unreasonably low speed limit, 25 miles an hour speed limit in a situation where easily it's a 45 or 50 mile an hour zone, and you get caught for speeding because that really, nobody was around, middle of the night, whatever it was. You can't say, well, I think that we should have living speed limits. And I think that what I was doing was quite reasonable and we should be able to do. No. You want to change the speed limit, you got to go through the process by which you do it. The same thing holds true for them. Now, the only way that works, and here's one other thing about that. We don't consent to the contract. No one asks us. If you're an immigrant, you do have to pledge loyalty to the Constitution. But if you're native born, you don't have to. But each and every person who gains power under the Constitution has to take an oath to uphold it. Nobody, from high to low, gets power under the Constitution without taking an oath to follow it. Now, that is consent. It's as good a consent as you ever do when you go online and you click I agree. It's more than that. They usually have to put their hand on a Bible and they have to raise their hand and they say, I take an oath. Now, what would that oath mean? If the oath basically said, I take an oath, this is my book, it's not the Constitution, we say, I take an oath to this Constitution, whatever I say it means. Well, that would not be an oath at all. So the meaning of this Constitution has to be identifiable independently of what they say it is. And that's where we get to originalism, that the public meaning, the meaning that words had to the general public to whom it was advertised, has to remain the same until it's properly changed by going through the amendment process. That's how we subject them to law. And it doesn't work if they get to decide what that law means. And that gets us back to originalism. Oh, and you want to know what the goals were? I think it's really important, especially for libertarians, to remember that the goal of the Constitution isn't just to limit government. The goal of the Constitution is to empower a government first. The first reason why they formed the United States and they gave up on the Articles of Confederation, even though some libertarians like the Articles of Confederation better, let's not debate that now. But the reason why they wanted a new constitution is because they thought that the federal government lacked powers that was necessary to put us on a par and make us competitive and allow us to defend ourselves from the European powers that were over here and they were messing around with us. And so they wanted a more empowered federal government. So the first thing that the Constitution was trying to do was to create a more powerful federal government than we currently had under the Articles. But then, having done that, they wanted to constrain it. So it does two things. It empowers and it constrains. And unfortunately, over 200 and some odd years, the powers have gotten bigger and bigger. The assumed powers have gotten bigger and bigger as the courts have deferred to Congress and what they think they can do. The constraints have gotten weaker and weaker. But that's one of the things that the originalist movement is supposed to be about. It's supposed to be reviving or restoring the original constraints on government power. And that's why progressives don't like originalism.
Originalism, I want to make sure I'm hearing this with clarity, that originalism fundamentally is simply adhering to the words as they are written.
Yes. In context.
So if you and I do a contract, we're going to try to turn this show into a scripted horror movie somehow.
I think it's already happening.
Yes.
I think we're well on our way.
We're in Act 2. And we come up with our contract and we write things down. I don't think there's anyone in the world that thinks that what is written down is not meant to be interpreted as it is written, because otherwise you wouldn't fight over the words.
Right.
So why is that controversial? Why is let's read the Constitution's words for what they say as words on paper because that's what they are, unlike England, which doesn't have a written constitution, right? So they don't have that.
Right.
We have it.
Right.
And we, like you said, all politicians take an oath.
And I debated at the Oxford Union about whether England should have a written constitution. I was arguing affirmatively they should have a constitution. I was arguing it against the former High Chancellor of England, who was arguing against a written constitution for England. So anyway, that was...
So why is that controversial? By honest people, not by just like partisans who just want their political things to happen.
Well, I think that explains part of why it's controversial. I mean, there were arguments made about earlier theories of originalism that were not invalid, that earlier formulations of originalism up until the 1980s had left some things to be desired. They weren't talking about the meaning of the words. They were talking about the intentions of the framers. And you can imagine that the intentions of the framers is going to be a lot harder to figure out what they are. And the question is really, is there one intention of the framers? There's framers, there's lots of intents. And conservatives who were originalists or proto-originalists, I would say, because there wasn't any real theory of it, just continued to assert the intentions of the framers. And then there was progressive pushback against that. And I think at that time that was happening, I was not an originalist and I was persuaded by the pushback. And I only became an originalist after that. And by happenstance, I'm the only person, I think, in the United States who became an originalist because I read a book by Lysander Spooner called The Unconstitutionality of Slavery. And I tell this story in the memoir. I was teaching at Boston University, and I would have considered myself a Dworkinian, which those people who are out there know anything about Ronald Dworkin. I was a student of Ronald Dworkin's. This is the moral readings theory of the Constitution. You want to make the Constitution the morally best it can be. Putting that to one side, that's I thought originalism had been refuted by the people who made these arguments against framers' intent. And then I'm reading, I have a seminar, and a footnote in one of the articles I assigned to the students was a citation to Lysander Spooner, The Unconstitutionality of Slavery, published in 1845. And I'm thinking, I only know Spooner for one thing that I read when I was in college, which was No Treason, the Constitution of No Authority, in which he argued that the Constitution lacked consent and therefore the Constitution was illegitimate. And I liked that when I was an undergraduate. I even liked it when I was a law student. But I didn't know he did anything else. So I had the library, get me a copy of the book, get me a copy of whatever it was. I didn't know what it was. And it turns out it was a 280-page book. It was published in 1845. It went through several editions. And it was part of the 6-volume collected writings of Lysander Spooner. And I didn't know who knew that he did so much. I became even a bigger fan of Spooner than I was before.
This is a early radical libertarian.
Yes, radical libertarian, who eventually did become an anarchist libertarian. Or maybe he always was, but a lot of anti-slavery abolitionists became anarchists, actually. So it would not have been unusual for him to become one. But at any rate, and what he was arguing for, he was arguing against relying on framers' intent. He was arguing against the radical abolitionists, the Garrisonians, who had been arguing that the Constitution was a covenant with death and an agreement with hell because it protected slavery. And then when Madison's papers were finally published, they were secret for 50 years. When they were finally published, Wendell Phillips, who was William Lloyd Garrison's right-hand man, a Harvard graduate, lawyer, student of justice stories, he published a book called The Constitution, a Pro-Slavery Compact, excerpts from the Madison papers. And in it, he just quoted all the things from the convention which showed that they intended to protect slavery. See, we told you that the Constitution was a covenant with death and an agreement with hell. They used to burn copies of the Constitution at their meetings, which did not make them very popular. It's one reason why anti-slavery people didn't like to call themselves abolitionists, because those are those crazy people over there who burned the Constitution. But Spooner said, 2 years after Phillips wrote that piece, that pamphlet, Spooner wrote The Unconstitutionality of Slavery, saying, look, we are not bound by the secret intentions, the hidden intentions of the framers. We're only bound by the words they used, the words on the page. And that really was the first basic dispute amongst originalists between framers' intent and public meaning, or original meaning of the words on the page. And I think Spooner was right. Methodologic. What happened was I read this. I went, oh my gosh, I'm a legal theorist. This looks like a theory I could work with. This is a theory of originalism that's not like the one they've refuted. This is a different theory of originalism. It came to be known as the new originalism. That is the originalism that all the justices on the court and the judges in the circuit courts who consider themselves to be originalists, they think they're original meaning originalists because of the new theory that was developed in the 90s and the 2000s by me and a few other people. So It's not that controversial today, but it isn't even what conservatives were arguing before. They were arguing framers' intent. They were not arguing the words on the page.
How could you? I mean, obviously, yeah, you find private writings that point towards an intent. But that is a really hard standard to try to live up to, and seems like so fundamentally subjective. And you could just drive a truck through the subjectivity of like, well, what did Thomas Jefferson really mean?
Right. Now, there is one level at which it sort of makes sense, and which I've even argued that it should be used. And that is not when you are interpreting the meaning of the text, but when you're deciding how to enforce it or how to put it into effect, because lots of these texts are more abstract or general. They don't automatically apply themselves. And you want to apply the text faithfully, then I think you should be faithful to, in some sense, the original ends, the original objects, the original purpose. This is true even when you're interpreting a contract. There's a spirit of the deal. There's the purpose of the deal, the purpose of the transaction. And at the very general level, you sort of can identify it. It's sort of like what I was saying earlier to you when I said, well, they wanted a more powerful central government because they wanted a more effective military to defend themselves from European powers. They wanted to negotiate trade policies because individual states were all over the place. They wanted to eliminate protectionist legislation within the United States. They had objectives. They were publicly known. These are not secret and hidden objectives. They're not framers' intent. They're publicly known purposes. When it comes to being faithful in applying the meaning on the page, I think you could at that level consult their ends, purposes, the problems that they were trying to address. I think those all become relevant. They go to being faithful.
What is the strongest argument on the other side of the aisle from you as a new originalist architect?
I think the strongest argument on the other side is that this is all well, and they usually start off with a really big concession, the strongest ones. This is all well and good for the really specific parts of the document, like 2 senators per state. The president needs to be 35 years old. There are rules in the Constitution. It's okay. It's all well. That's what Justice Kagan meant when she said we're all originalists now in her confirmation hearings. She was talking about the hardwired or specific rule-like parts of the Constitution. Now, I think that's a major concession. Because after all, if you think it's fundamentally unfair that California has 2 senators and Delaware has 2 senators and Montana has 2 senators and California shouldn't have more, why should you be bound by the words on the page, even though it is a rule? So I think they've made a major concession to originalism by that. But then the next step they make, and this is, you say, what's the strongest argument, is that, well, when you talk about the more abstract provisions, though, the ones that aren't so clear, the ones we litigate and fight over, the due process of law, the equal protection of the laws, and other sort of things they say are general and vague, at that point, the meaning on the page isn't going to help you very much.
Promote the general welfare.
Right. The meaning on the page is not going to help you very much.
So what does that mean, the general welfare?
Right. So there's at least, so I think that's a very strong objection because it is in fact harder to know what to do with those. And I think there's at least 2 things you can say. I mean, there's probably more, but 2 things at the moment I can think of to say about that. The number one thing is, and that is that if you do more work, this is what they say. These are very general, but this is what can be what some of us call armchair originalism. They haven't actually done the work. They're looking at the words and they go, well, that could mean anything. But if you actually do the work, you're going to find the words. There's actually more words there than you're saying. They call it the due process clause, but it's really the due process of law clause. Those 2 words mean something. And it's the equal protection of the laws clause. It's not the equality clause, as it's sometimes referred to. So if you do more originalist work, you're going to find there are more words on the page, and those words had a more concrete meaning, and they're not as open-ended and general as you say they are. So that's number one response. Then the second response is that even when they are, and they will be at some point, a more general rule or principle has to be applied. At that point, that's when you look to the original purpose in the sense of the original function, the original end, the original objects. What was the design for? That's a little bit what Justice Roberts did in the immunity case. He looked at you look at 3 separate powers, the Article 1, Article 2, Article 3. These are separate powers. There's no separation of powers clause in the Constitution, but there are 3 separate powers. So what were they trying to accomplish when they made 3 separate powers? That's kind of what he was doing there, and that's something that is not uncommon. It's very common. People who are critical of originalists, relying on framers' intent, conceded up front that at that level of generality, identifying public purposes is not so impractical. You can really do it.
Has the Constitution failed?
Not yet.
Let me make an argument for that the Constitution has failed, even if I don't know that I believe it, just
Okay.
to find what I mean. If the goal of the Constitution was, yes, to empower the government, the federal government, so that it could protect us from Spain and France and who were licking their chops after we kicked out the British. Okay, fine. In that sense, succeeded. We've got, you could say, from sea to shining sea. We're still here. But if the idea was to create these separate powers that hold each other like the strings over, like Lilliputian strings over Gulliver, it seems like that's failed, because the president can do a lot, and we've got millions of people working in the executive branch, carrying guns in like IRS and Health and Human Services, doing all kinds of stuff. They're arbitrarily telling us that when we breathe out, it's pollution, or how fast our car should go. It seems like we now have one thing, and that one thing isn't simply the presidency, but it is actually this more permanent structure, which you alluded to earlier in our conversation, a kind of deep state. Permanent employees that have essentially all the power that used to be separated, and they're there year after year, and we just rotate this guy or girl at the top out, and they're there doing their thing that they want to do. So in that sense, has the Constitution failed? Can we get back or go forward in a way that restores it to being the thing it was intended to? Or is it kind of game over, 250 years, not too bad?
Well, I've changed my mind about this over the years. When I was a law student taking constitutional law from Larry Tribe at Harvard Law School, I gave up on the Constitution. By the time I was done, and I tell this story in my book, by the time I was done with the course, I was done with the Constitution. Why? Because every time I got to one of the good parts of the Constitution, be it the 9th Amendment or the 10th Amendment or the 2nd Amendment in those days or the Commerce Clause or anything else, I thought, well, that's good. I like that one. Then I would turn the page of the casebook and find out the Supreme Court has ruled that that doesn't mean anything. It's not operative. We're going to go by. They're going to have a doctrine that gets around it. And so by the time I got to the end of the course, I thought, well, I was a patriotic American. I like the Constitution, but it obviously has failed. So it's time to move on. I mean, and when I went into practice, I became a criminal prosecutor. And when I went into law teaching, I was a contracts professor. So that was the answer I gave in those days. However, I do think it's true that we still remain amongst the freest country in the world. You know, whether we're technically the freest or not, I'm not going to say, but we're amongst the freest countries in the world. And why would that be? And I think it's because features of the Constitution that have not yet failed. Most importantly, federalism has not failed yet. Now, it's true.
Define federalism for those who are watching and are like, I'm not sure what that means.
Federalism is the fact that we have 50 state governments that each have their own powers and they can each make policies. And then we have this federal government on top of that. Now, there's lots of things wrong with our federalism that has been weakened in various ways. On the other hand, some of the weakening of federalism was done on purpose in the 14th Amendment after the Civil War, and for good reason. And so I'm for that. So I'm not for unlimited state power, but I am for a separation of powers between federal and state. And we still have it. And where we saw it was during COVID. Federalism was there for us.
It was there for me in Texas, that's for sure.
Well, and it was there for me in Florida when I moved from D.C. to Florida. I moved to another jurisdiction. I could stay in the United States of America, and I could move out of crazy D.C. where people were crazy, and I could move to Florida where people were sane. Even in Central Virginia, people were a lot more sane, but in Florida, they were a lot more sane. And we had policies in Florida that were more sane. And in Georgia, they had more policies that were more sane. And the fact was that the federal government, that the president conceded that he did not have the power to impose certain kinds of mandates on the country as a whole. He kept getting asked about it. He kept saying, I don't have that power. That's a power that's left to the states. And then there were blue states like New York and California and Michigan and other states who imposed draconian regulations and restrictions on liberty under our federalism. And then there were states that didn't. And you could move to a state that didn't, like I did. And the states that didn't have draconian policies provided an example of how not terrible it would be if you didn't have them. So if everything is debating at the national level, and one side says, we need this gun control, we need this, and if you don't, we need this, whatever it is, and if you don't have it, disaster is going to strike. How are you going to prove them wrong? But if you have 50 states doing stuff, and 5 states do it one way, and 10 states do it another way, you can compare. You could say, really, was it a disaster to open the schools?
A laboratory in democracy.
Right. And so that part of the system we still have. And it has been working for us. During COVID, the federal judiciary was absent without leave. All the conservative judges, the originalist judges, there's only one thing they finally got around to policing, and that is religious liberty, restrictions on religious liberty. That if you're going to we're not going to allow this bar to remain open and not allow this church to remain open. We're not going to allow that. If the bar can open or whatever it is that could open, then a church could open. So they did finally get around to protecting religious liberty, but that's the only liberty they protected. The rest of us were at the mercy of our states, but federalism was still there to provide some protection for us. So it has not completely failed. Here's the way that I look at it. When you have a modern jet aircraft, there's a lot of redundancy built into that plane, and you can lose a system or two and the plane will still fly. In the case of the engines, if it's a 4-engine jet, you can lose 3 engines and the airplane will still fly. Now it's not going to fly as well, and you would like to get those engines fixed, but you haven't crashed. We haven't crashed yet. We're operating on 1 engine. And the originalism movement is trying to start up some of these other engines and is having some limited success in starting up these other engines. We're in a slightly better position with the reversal of Chevron and Heller and a few other things. We're in a somewhat better position. Maybe we're up to 2 engines. I'm not sure what my metaphor maybe. But the point here is that is the mission of originalism. And if the 2016 election had gone the other way, and Hillary Clinton had won, and that seat that was being held open by Majority Leader McConnell had been filled by her, and then the court flipped over, I think it would have been game over. And I was, at that point, since I thought she was going to win, and I talk about this in the book, my game plan was to go back to teaching contracts and then retire. And I was at the age where I could retire. I'm past the age where I could retire now.
I will retire along with our constitutional structure.
It was like, it would have been no point anymore. But that didn't happen.
Is that hyperbole? Is it really that pivotal? Is it not? Is it not reversible?
That election was.
It was.
2020 was not. Not every election is like that. That election was, because the Supreme Court was in the balance, which it almost never is.
One of the things that's so interesting is that we live.
Oh, and that's the other. And the other thing is that there had to be a political movement to demand that Donald Trump fill that seat with an originalist, because Donald Trump doesn't know about that stuff, but George Bush didn't know about that stuff. No. They don't know about that stuff. So there had to be a political movement to make that happen, and Donald Trump had it in its interest because he wanted to secure the nomination and secure the support of the Republican base, and he made a promise. He made a public promise that he would do it. And then, lo and behold, somewhat to my surprise, first of all, I was surprised he got elected, but secondly, I was surprised he kept his promise, but he did. And so now we're ahead of the game. So it hasn't failed yet, is my answer.
I like that. I like that provisional optimism. Hasn't failed yet. I'll take it. A life for liberty. We've talked a little bit about our libertarianism. And
by the way, in the book, I talk about how I got involved in the libertarian movement when I was in college. And when I went to law school, I was befriended by Murray Rothbard and got involved in the New York Circle of Intellectuals. And I was down there instead of studying for my, in law, being a good law student and like I should have been. I was put on the board. I joined the board of the Center for Libertarian Studies during my second semester of law school. So I spent a lot of time in New York. We put on the Libertarian Scholars Conferences, and I ultimately put on a Liberty Fund conference at Harvard Law School on crime and punishment. And so this talks about, in some sense, the book is also my first-person recollection of the history of the conservative legal movement, but it's also my first-person recollection of the history of the modern libertarian movement.
So from your perspective, what is libertarianism as a philosophy?
Libertarianism, I think, is the philosophy that the liberty of the individual has to be the primary. If it's not the only, it's got to at least be the primary goal of a political order. It is the political and the job of the political system is to preserve and protect and defend the liberty of the individual, but not as an end in itself, but as a means to the further end of individual flourishing. So you have to understand not only what rights we have and why we have these rights, but also not only what rights we should have, but also why those rights are instrumental to allowing us to fulfill our function as human beings and to achieve our ends, our natural end as a human being, and flourish as an individual. And that is the function of government, is to protect the rights that are prerequisite. They can't guarantee you that you will flourish, but they are the necessary elements of flourishing when you live in close proximity to other people.
Does that philosophy, does that unit of analysis, the individual, necessarily point towards Lysander Spooner and Murray Rothbard, which is to say a kind of pro-private property anarchism?
Here's what I want to say about libertarianism, and that is that libertarianism is not a single theory, and it's a mistake to think it's a single theory. Libertarianism is a family of theories. That's true of originalism as well. Originalism is not a single theory. It's a family of theories. And so there's a new book. I'm going to finally recommend a book that I did not write, and it's a book by
I appreciate the promotional zeal.
Yeah, Matt Zwolinski and John Tomasi have written this wonderful book that came out last year, and I've reviewed it for the Claremont Review of Books. It's called The Individualists, and it's an intellectual history of the libertarian movement. Totally recommend it, and you should have them on your show.
Yeah, that's a good idea.
And in it, they talk about not only is libertarianism a family of theory, they talk about the family resemblances, the 6 characteristics that libertarians share in common, and I haven't committed them to memory because it's not my book. But they also talk about the 3 phases of libertarianism. Because I would have thought, before I read their book, I would have thought, well, libertarianism is basically the Rothbardian type libertarianism, or Ayn Rand, or the people that we're dealing with in the 70s, the 60s, 70s, and 80s when I got in the movement. But their thesis is that was the second wave of libertarianism. The first wave of libertarianism in the United States was the anti-slavery movement. They were the original libertarians. And then we are now in an area where there are a third wave of libertarianism. There's left libertarianism, there's paleo libertarianism, and there's bleeding heart libertarians. These are different versions of libertarianism that are kind of on offer out there right now. And I was vaguely aware of them. But I think with their telling that I think each one of those things is onto something. So I do think that a libertarian model that I participated in helping to develop when I was a law student and right after law school, as part of this Center for Libertarian Studies, et cetera, I think the libertarian model needs to be updated and refined. It's sort of been frozen in place for 50 years. And these different movements are onto something about things it might need, but that's for future work. It's not something I know how to do at this point.
One of the things, so my own journey into this world of ideas began with Ron Paul, actually. Like, I was like a young Republican growing up and didn't really know much about anything because I was a kid. Whether I know that much about anything now is up for people to judge for themselves. But I encountered Ron Paul 2007 and 2008. And against the backdrop of the financial crisis, I found that Austrian economics perspective, that sort of radically individually subjective perspective, the notion that value is subjective, it's in the eye of the beholder, and that from that starting point, which I think is very powerful, you can demolish socialism, Keynesianism, these things on offer that dominate the political order. Because you don't know what I need, so how dare you tell me what I need? You don't know. You're not in my head.
Right.
So leave me alone. It's like kind of that simple. What I've been struggling with, maybe it's a function of age. I was talking to another fellow, like kind of hardcore libertarian, who was like, "Oh my God, we're like thinking about the same stuff," like Sheldon Richman.
I know Sheldon from back in the day.
Yeah, he's like an awesome graybeard libertarian guy. And that's that there seems like there might be like a soft underbelly that has been stabbed by identity politics or wokeism or our moment, which is the you do you lets some nasty people into the room that are willing to slit your throat. It's sort of like why the worst get on top. There's something, if I was going to say it's like the broader movement of, let's say, liberalism, there's some weakness in it. And I don't have a fully formed sense of this really yet, but it does seem to be there. And one of the things that's like conjuring in me is sort of turning toward my Catholic faith and saying, it seems like if you don't, like the founders certainly talked about, you need to have a moral people to have a free society. And even at the systems level, it's like no system contains within it, logically, mathematically, its own measuring stick. You always have to look from without to try to understand the within. And have you been grappling? Is this making any damn sense? Or
Yeah.
am I off in weirdo land?
No, not only are you, well, you may be off in weirdo land. I can't speak to that. But not only is it making sense, but you're not alone. This is actually a pervasive feeling amongst people who have identified as libertarians their whole lives, some of whom no longer call themselves libertarians anymore because they're bothered by a lot of this stuff. And I had a piece on July 2nd to sort of commemorate the publication of the book on the Law and Liberty website that's published by Liberty Fund called Libertarianism Updated. And then I identified the 5 things that I think libertarians need to think about harder in order to update their theory. And this is something for my future work. It's going to be a future book of mine, so I haven't done the work yet. The first thing was that libertarians who believe in natural rights need to also be more serious about natural law ethics. That is, they need to be more serious about the nature of human flourishing. And I already gave that answer earlier in this podcast where I said the rights that we have to be good for something, and they have to be good for human flourishing. And then human flourishing takes on certain forms based on our human nature. This is something that might actually harken back to your religious past. And so there is such a thing as a good life and a bad life. It isn't anything goes, and then you could be happy. Now, it doesn't mean the political system should be telling you what to do, but it does mean you need to get that from somewhere. So the first thing that I think libertarians need to do is to be more incorporate natural law into their natural rights approach. The second thing I think they need to do is to understand that libertarianism, as you have alluded to it when you keep referring to anarcho-capitalism, is what philosophers would call a ideal theory, meaning this is how the world might work, and it might work better than the world we have if it was fully implemented. And that could be right. In other words, you could work it all. I mean, you could be wrong. You could say, no, if you fully implemented this, it would be terrible. That you could have a debate about, but you could be right. It's not a utopian world in which it requires a change in the nature of reality for it to work.
Yeah. We don't need to have socialist man.
Right, exactly. Ideal is not the same thing as socialist, but it has to be fully implemented. What libertarianism also needs, however, is not just an ideal theory, but they have to have a theory of the second best, a theory of what a libertarian should be for in a world where you have 175 competing nation states, and you're not in the state of nature. And so that is something else that libertarians need to, and because it isn't true, and some libertarians, I think, naively think that if the end is no government at all, then we should just chip off and eliminate whatever we can eliminate, and that's going to put us closer to the ideal. But it's not. Because in a world, for example, of nation states with national borders, eliminating immigration controls or eliminating borders could be very bad in a world of nation states where there are other terrible nation states out there that people want to get out of, et cetera, or they want to do us harm. So I think libertarianism needs a theory of the second best. I think the other thing that's wrong that libertarianism lacks, because it's a state of nature theory that says what is just in a state of nature, it lacks a theory of the civil society. It lacks a theory of citizenship. When you leave the state of nature and enter into civil society, what you get is, in addition to your natural rights as a means of protecting your natural rights, you get civil rights. These are the rights you have within civil society. This is something the Republicans understood. The anti-slavery people understood it, and Republicans who passed in Reconstruction, they understood the idea that citizenship, like American Express commercial used to be, membership has its privileges. Citizenship has its privileges. You're a member of the society, and you get certain benefits from that. So you need a theory of civil society. You need a theory of citizenship. And I think, I'm not sure if I've gotten through all 5 of them, but the 5th one I'm going to talk about is that libertarians need to think harder about threats to individual liberty that might be coming from what's so-called private power instead of public power. Actually, this is number 4. I'm back on my list again. All right. So, so I think what they need, we have.
So when YouTube says you've had enough viewers for today, Popola.
Look,
that's that I should be worried about that. Even if it's still a private enterprise.
There are certain things that I know can get this podcast demonetized if I start talking about it. You don't want me to start talking about that stuff because you don't want to be demonetized. So I don't know if YouTube would actually qualify, but we have to distinguish everybody, and it isn't just libertarians. Conservatives do this and modern liberals do this. They equate the public-private distinction with the government-non-government distinction. So public is government, private is non-government. But what if those aren't one binary? What if those are 2 binaries? Public-private is one binary. Government-non-government is another binary. They're not the same. And then what would happen? We'd have 4 categories. So we would have, for example, private non-governmental, where nobody can tell you what to do inside your own home, in your own bed, who can you sleep with, whatever. So you have private non-governmental. You have private governmental. Military bases. Individual citizens can't wander onto a military base. That's their turf. So in between those 2 things, then you have public governmental, streets, alleyways, sidewalks. That's understandable. Government can't, do everything. They can govern those areas, but you have rights again. You have rights of public access. That leaves one more category, and that is private and public non-governmental, like common carriers. Like the cell phone companies we were just talking about. Cell phone companies are non-governmental, but they're also common carriers. They serve a public function. Should they be monitoring using AI all the stuff we say and start canceling us off when we start saying the wrong thing on cell phone companies? So libertarians need to be a little more concerned about the threats to individual liberty that public non-governmental groups might be able to form. Now, I don't know that YouTube would be in that category or that Facebook or Twitter would be. But some people are. Cell phone companies surely are. And then the final thing that I think we need to think about is corporate power and the threats that corporate power might be able to bring. Something the left, of course, is concerned about, has been concerned about. But the thing about the left is that they want to collapse the public-private distinction and make everything public. We don't want to do that. We think there are things that are private. The point is that sometimes non-government institutions can be a threat to us, to our individual liberty.
One of the ways I've tried to think about this in a simplistic model is that if you take the way people talk about freedom, colloquially, they will say things that are sometimes libertarian and sometimes not libertarian at all. In fact, I did some work with the State Policy Network where they did polls, and 50% of people, everyone liked freedom. 50% thought freedom involved more government, and 50% thought it involved less. And so this term freedom, like, oh, if I didn't need to get my health insurance from my employer, I would be more free to take a different job, for example. That's not an invalid way to think about being free. And so I'd be curious how you think about this. One way to articulate freedom is to say freedom is the lowest cost of exit. The freedom and our cost of exiting from the thing we wish to be free from are in this inverse relationship. So I am relatively free to quit a job in a world where there's a lot of job opportunities. I'm less free to quit a job in a single company town with a mother who's on dialysis, who relies on my income to keep alive, and moving would be very, 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 very difficult. So I'm less free to quit that job. I'm less free to move states than I am to move cities. I'm less free to move countries, certainly, than to move states. And so freedom is on this spectrum relative to the cost of exiting. And I think that is one way I've tried to think about how to bring in the legitimate concerns of progressives and left of center people who are worried about whether it's corporate power or access to things that they think are really important, like access to healthcare. This access term is also often used. How do you think about that?
First of all, this is work to be done. This is my next project. I mean, I actually have two next projects. One is to take the chapters on my being a criminal prosecutor in Chicago that I had to eliminate from the memoir because the memoir was too long, and make that a separate book called Felony Review, Fighting Crime and Corruption in Cook County, which will all be about my experience in the criminal justice system, which was kind of singular. And the other book is going to be a book about how libertarianism needs to be updated. I think what you're saying makes a lot of sense. And I wouldn't disagree with it, but I just think right now I'm at the point where saying we just need to think harder about this and not think that those questions are unlibertarian. In fact, as long as you keep individual freedom at the center of your focus, then you are being libertarian. You're trying to be libertarian. You're just trying to be more realistic about what libertarianism actually what liberty requires for human flourishing, in the real world.
There is a term that you've argued for, polycentric legal order. What does this mean?
In the Structure of Liberty, which was my first monograph, which was my defense of libertarianism, I talk about why we have certain rights and why we need the rule of law. And the reason why we have certain rights and we need the rule of law is because of the need to address three categories of social problems. Problems of knowledge, which you alluded to earlier when you talk about you don't know what I need, you don't know what's in my head. Problems of interest, which are people who basically are pursuing their own self-interest detrimental to others. And then if to solve the problems of knowledge and the problems of interest, especially the problems of interest, you have to introduce coercion or force, which libertarians do. Unless you're a pacifist, you do believe that self-defense and the use of force is justified.
This is my property, therefore, if you just start building something on it, I have to be able to do something about it.
Right. So if you're allowed to use force, you introduce force as a solution to people who are basically violating the rights that are necessary to solve the other problems. Now you've got a problem of power. That's the third problem. The third category, the problem of power. And in the Structure of Liberty, I postulated that we should handle, we could handle, and again, I'm going to say I was presenting an ideal theory here. We could handle the problem of power by having competing firms. I postulated that we should have competing law enforcement firms in the sense of police firms and competing judicial firms, and they should not be the same thing. But we could have competition amongst these, and then instead of getting the legal jurisdiction that comes with the territory, you get the legal jurisdiction you opt into. The way I said earlier that you should put private arbitration clauses into your contract and opt into the AAA. So that's what I was proposing as a more effective checks and balances system than our Constitution is now providing. It's trying to do what the Constitution is supposed to be doing, but is not actually doing. But I do think that what I was putting forward was what I would today call an ideal theory, not necessarily a real world theory. I think it would work in the ideal world. Polycentric means multiple centers, multiple competing groups. We have multiple competing governments now. This would be non-geographical competition. Anyway, I think it could work in the ideal world. That doesn't mean it can automatically translate into the real world. But one question is, why did I even bother putting that into the book if it's just an ideal theory? What's the point of it? And here's the point of it. The argument made against making one step in the direction of more liberty is that, well, if you take your argument to the logical extent, then you're going to have no law enforcement at all. You can have no government at all.
Right.
And
it'll
so
be anarchy in the burn stuff down in Seattle.
Yeah. And so it's that if you take an argument against taking one step in this direction is that the logical consequence is to go all the way here, and here is terrible. But what if you could say, oh, no, wait a second. It's not an objection to take this one step, because if you went all the way here would not be bad.
Sort of an inverse slippery slope.
Yeah. So
a slip and slide.
If you can show that going all the way there would actually be a good thing, not a bad thing, that undermines an argument against taking one step today in the real world in that direction. And that's the reason why I thought it was worth putting in the book.
Second to last question for the day. We've talked about a lot of big ideas about perfect and the second best and how to navigate this time. How do you think about, because you clearly have a very deep sense of why ideas matter, even when they are abstractions that are only in the service of an argument that's being had among legal scholars. And I'm walking down the street trying to live my life. What the hell are you talking about,
Right.
Randy? What has this got to do with anything? So what does this got to do with anything? Why do these ideas matter? Why do visions of a better world that can be abstract and can seem impossible, and maybe even are impossible, why do they matter?
Well, this sort of is the thing that's animated my whole career. It is the unifying theme of the life for liberty that I describe in the book, and that is justice matters. The ideal of justice matters because we carry, and as other ideals do, because we carry these around in our head. Everybody carries these around in their head. They're just not thinking about, they're not reflecting on them. That doesn't mean they don't have them. It's what opinion polls are based on. It's why people say, well, I'm for this and I'm not for that, because they have an idea that they're carrying around in their head. And it's inevitable. People will have these ideals in their head. They'll have these ideas in their head. Now, the question is, are they right or not? And I think the world would be a better place if we take these ideas and we subject them to scrutiny and we try to make sense of them and we try to say who's right and who's wrong and which is stronger and which is weaker. And it is a division of labor. That's not something anybody else has to do. Everybody else. There's lots of other jobs in the world. There's a trained crew here that are doing their jobs to make this podcast possible. And if they don't do their job, this podcast is not going to go off on the go onto the air. So everybody doesn't have to do this job. But as a division of labor, I think some people should. And that's what eventually I decided to do with my life. I started off watching a television show called The Defenders when I was 10 years old, which was about a father-son criminal defense team in New York. Came out in 1962. And it was a great show about being a criminal lawyer. And I had not any idea that I wanted to be a lawyer. We had Perry Mason on in the house, but that was about solving murders. And that didn't attract me. But this was a show about being a lawyer. I didn't know that's why I liked it, but it was a show about justice is what it was about. And that just got me to the core. And it was because of that I became a criminal lawyer. No matter what else I was tempted by, I stayed on course to be a criminal lawyer because that image was planted in my brain when I was 10 years old. But eventually, when I got to college, before I was a criminal lawyer, and I discovered philosophy, which I had never heard about in high school, and I discovered natural law philosophy, and then I discovered libertarianism, I realized, maybe I'd want to be an academic of some kind. First, I thought maybe a philosophy professor, but that I ditched that idea and stuck on plan A to be a lawyer. But maybe I should do this full time and try to figure out what justice really is. I mean, it's one thing to be for justice. In some sense, we all are for justice, but then we're not always sure what that means. So maybe it would be worth my time as a division of labor that I should start examining these things. And I did, and it led to the structure of liberty, justice and the rule of law. Justice is right there in the title. And eventually, it led me to think that I could maybe achieve a more just world if I could revive the original meaning of the Constitution. Because if it was fully followed, I think we'd have a better world. I think we'd have a better society. I think we'd be freer and we'd be more prosperous and we'd be happier if the whole Constitution was followed. And so that's something that I thought I could contribute to. But really, and it would take the ideas that were ideal theory and it would put them into the real world context because I can litigate. I can bring the medical marijuana case out of California. I can litigate the Affordable Care Act case. And so it's a way, ultimately, it was a way of putting the ideas that I've been working on in service of reality, in service of how do we actually implement these. And the last part of the book is all about how did we get originalist judges? How do we improve the judiciary? And you mentioned Ron Paul earlier. There's a whole chapter here about how I was one of the senior advisors to Rand Paul for his presidential campaign. Rand had read my book, Restoring the Lost Constitution. He's a big constitutionalist. He really liked the book. And he had asked me to be his advisor on his campaign. And I was inside the room during the debate prep that we did. I played Chris Christie during the mock debate. And so it was fun. But part of that election of 2016 was how we got to an originalist court, a more originalist court than we've had in my lifetime.
I usually end every episode with a question about the role you play in the American story because this is Dad Saves America after all.
Yeah, what
But-
is Dad Saves America? Can you explain that to me?
Well, you flipped the end of the script, and that's good because you just answered about as well as I could imagine what would be my final question, which is how do you see your role in the American story? So I'll take the bait and answer. As we've talked about philosophy, about libertarianism, about justice and flourishing. What does it mean to pursue happiness? What's occurred to me in the past, really in the past 5 years, is that there are some fundamental things that come before the demand for a free society, the demand for liberty. And I like to think of them as the freedom philosophy, or really the freedom mindset. And I kind of think of it in two categories. One is, do I have agency? Do I have an internal locus of control, as my psychologist friends like to say? Do I believe that my choices matter for myself and that they matter, period? And have I practiced that? Have I done it? I believe it because I do it, because when I exert effort, I see a reward or I see a change. And the second piece is, do I believe that change is possible, like a growth mindset? And I think you have to experience those things too. You have to overcome challenges. You have to touch the hot stove, learn from the burn, and survive it and be like, oh, okay, I can do a thing that hurts and was dangerous, but it didn't kill me. I'm stronger now. And I think this mindset is something that we as men, in our role as father, give to our kids in a very, very particular way that is very special to being a father. And I think that the collapse of fatherhood in this country, we lead the world in fatherlessness, is a root cause of a lot of the problems we face in this country. That when you don't have dad saying, go ahead and climb the tree, and you don't get to experience that you got to climb higher than you thought you could, which means maybe you don't even know your own capability, which means when somebody tells you that they think they know your capability, you know they're BSing you because you don't even know your capability. That is foundational. And so that's where the dad comes in here.
Well, when you read this book, and I know you're a busy guy, I think you're going to like it, because my first mentor that I talk about was my father. There's a chapter devoted to my father and how, if it weren't for him, I wouldn't be me, and exactly why, what he gave to me, how he gave it to me, and how, I will always be, in some sense, his son. That comes back and again in the book, that I'm my father's son, and that's why I'm doing this. And so this book is a testimony. This is a living testament to that proposition being true.
Randy, thanks for being on Dad Saves America.
Thanks for having me.